and we can get started. So good afternoon, everybody. Happy New Year. Appreciate you taking the time to join us for this session. We're going to cover a lot of topics around restrictive covenants. And I'm happy to say that Jim Anelli from White and Williams, who's also a board member, he and I talked a couple of times over the last week. And I appreciate, Jim, you letting us know about the FTC rule proposal. You've probably seen our emails previously that New Jersey has tried to pass legislation, will probably continue to try to pass legislation on restrictive covenants. So it's definitely making the news. We could kind of go over all the various types, non-solicitation, non-competes, and other types. So with that, Jim, I'm going to turn it over to you to kind of set the stage and
sure,
and start the discussion. So thanks, everybody.
Thanks, Tony. Good afternoon, everyone. So yeah, let me set the table. And by the way, this should be really informal. And I'm going to focus on the FTC rule. This rule is breathtaking in scope. It probably is the single most, in terms of rulemaking and scope, it's the largest rulemaking exercise in terms of changing the law in the United States that I have ever seen. It literally will change if it passes, and it will be challenged in court. It will change the law in all 50 states with respect to non-compete agreements at all levels. And it is a remarkable rule-making attempt by the FTC. It will be challenged as overbroad, and based on a recent Supreme Court case last summer, it'll be challenged on federal grounds as being unconstitutional. But right now, the rule has been adopted for comment. So those of you who are aware of how federal rules work, the agency adopts a potential rule for comment. It's published in the Federal Register. There's typically a 60-day period where the public can comment about the rule. And after that period, the rule is published typically in the Federal Register, and then generally within a certain number of days, the rule becomes effective and enforceable at the agency level. What the FTC has done in simplest terms is to say that all non-competes in the United States with respect to every worker, with respect to independent contractors, will be deemed to be an unfair trade practice and therefore will not be enforceable both on a going forward basis, and all existing non-compete agreements will become null and void within 6 months of the passage of the rule. So as you can see, this will, according to the FTC's numbers, impact about 35 million people who are subject to those agreements. The term non-compete agreement in the commentary to the rule is meant to exclude what individuals would call confidentiality agreements, non-solicitation agreements, and other types of agreements that do not restrict where an employee can work. However, the commentary also says that if the provisions in a contract are so broad that effectively it would prevent the employee from being able to secure work for a competitor, even though not being delineated as a non-compete agreement, that those provisions would be subject to Section 5 of the Federal Trade Act Commission rule and would be deemed to be unenforceable and in violation of Section 5 of the Federal Trade Act. So what you have here is a very significant rule that's very broad. Perhaps most interesting, and at least in my opinion, is the supremacy provision that is within the rule itself. The supremacy provision states that this rule will be supreme with respect to all other state rules and state laws, so that it will preempt all state laws that may exist or common law in those states that may not have a state statute. So with respect to the members of the CIANJ, you should assume that all existing non-compete agreements with employees, including senior executives, would be null and void if the rule passes. One of the things that is also interesting is there's an exception for buyer and seller. So those of you who may have bought and sold companies or who represent senior executives, you know that it's very common to have non-compete agreements around a buy-sell agreement. It's very common to have non-compete agreements with senior executives pursuant to a merger and acquisition. Right now, the standard that is in the proposed rule is that the individual would have to own at least 25% of the organization in order to be exempted out of the rule. So let's say you had a CFO or CEO of a company who owned 15% or 10% of a company being sold. It would not be possible to tie that individual up from going to a competitor. So from an economic standpoint, from a broader perspective, you have a situation where this dramatically impacts corporate law in the mergers and acquisition area. And it would dramatically defeat the ability of a buyer to, unless the individual was given 25% of a company, which, as you probably know, in many large companies is not a realistic possibility. So whether the FTC has intended to do so or not, they have created a rule that is supremely problematic as it compares to existing law and the changes to existing law. That fact was noted by the dissent. So there was a dissent filed. It was a 2-1 vote at the FTC. The dissent, in a scathing opinion, indicated that the other 2 commissioners who ruled in favor of adopting the rule was changing several hundred years of common law, and at the same point was doing so by essentially preempting the entire field of contract law under the guise of the FTC regulation. We will undoubtedly see litigation once the rule is adopted, assuming it is adopted. That could happen, I would say, in late spring of this year. What we had talked about, Tony and I, was submitting a comment during the comment period, which is currently running, on behalf of the CINJ to express the opinions of the members that this rule should not be, number one, should not go forward. But if it does go forward, there are issues, and they've been brought up. The FTC has said, well, if we decide to accept, well, they will accept comments, but in reviewing the comments, they've suggested that individuals point out if there should be any limitations on the rule, particularly with respect to certain industries or certain individuals. However, to be frank with you, the way they've described it, I'm not sure that it's actually helpful, because they're indicating that even for example, one of the things they said is for senior executives who earn a fair amount of compensation, they indicated that there may be a reason to relax the rule in that area. But even there, what they're indicating is that it would be presumed to be illegal, and that the employer would have to show by clear and convincing evidence that the presumption that it doesn't harm the economy. It would have to come forward with expert testimony and proof that the particular contract would not impact the economy as a whole if it was allowed to proceed in that way. And so while the FTC seems to be indicating that it's receptive to certain limitations in the enforcement, particularly with respect to senior executives, the test it's suggesting that it would use in order to decide whether on a case-by-case basis that exemption should be applicable would be almost impossible for most employers to meet. In addition, what is fairly clear too is through the supremacy provision in the rule, state courts, and by the way, it's typically state courts that decide these issues on enforceability. It's a contract question. They typically go to state court. The question right now is whether the state courts, in an action to enforce a non-compete agreement, would take into account this FTC rule or ignore it right now, or alternative. In all likelihood, I think most of them would probably wait until the rule is enacted in, say, 60 to 90 days. At that point, I think most state court judges, if they decide to uphold the FTC rule, which I think they would be obligated to at least pay attention to, may well shift the entire enforcement of these agreements, saying the FTC has found that these are unfair trade practices. We find that these are not in keeping with the public policy, and therefore, given the FTC's lead in this issue, we not only have trouble enforcing non-competes, but we may also have trouble enforcing other aspects of the contract, the contractual, the contract before them, such as non-solicitations or possibly even confidentiality provisions. So it does lead to a real conundrum down the road as to where this would go. And I think this is the first time, Tony, you and I have ever spoken about this, but I think that this is important enough where it warrants submitting a comment to the FTC on this issue on behalf of the business community in New Jersey.
Great.
And at that point, I think that gives you a pretty broad view, and I'm happy to take any questions or discuss any aspect of this at this point.
Jim, can I start by when are the comments due?
The comments are due 60 days after it's been published in the Federal Register. The actual rule itself, I believe, was adopted on the 5th of January. And so
by March 5th. March 5th.
Yeah, I would use March 5th as the date, although generally it takes a day or two to get the proposed rule into the Federal Register. So okay. It may be a couple days after that, but that's a good date to use.
I have a quick question, and it's like the next generation of this, but as far as the non-compete piece, that's somewhat understandable, not entirely agreeable. But what about the non-solicitation portion of that? Obviously you can walk out the door, you can have another job when you start poaching an employer's clients, using confidential information, et cetera, where are they trying to draw that line of, once they leave, what they can do, and whether or not you can be prevented from soliciting some, a prior employer's clients?
Yeah, right now, the only guidance that we have on that point is that it's not their intent to cover non-solicitation provisions by the term, non-compete agreement. However, they caution that if the non-solicitation is broad enough, it will be construed as a non-compete agreement. So I think your question is, where do those intersect, and how do those intersect? Exactly. And I would say that, first of all, it probably will be the case that they'll get an extensive number of comments on that. So I would expect that the FTC, through the rulemaking process, will probably beef up that language and maybe make it somewhat more clear-cut than it is right now. The other aspect, if they don't do that, is that the judge hearing the matter would have to make a determination as to whether or not the non-solicitation is too broad. And as you know, the way judges rule, I could bring an issue in front of 10 judges and get 10 different results. I would say, however, in general, the intent of the FTC is not to cover those if they're run-of-the-mill non-solicitation provisions.
And Jim, Franco just sent everybody a note. I guess they were published today. Or I'm sorry, the Federal Register today. So comments would be due March 20th.
Okay.
Well, I certainly would be in support of, offering an opinion, or this group offering an opinion on this issue. It's a pretty important issue.
It's an important issue for my clients in the corporate area, because it really does impact in a large variety of settings the ability to buy and sell companies, through mergers and acquisitions. It creates a lot of issues in that area.
Jim, let me read the comment here from Lewis. You mentioned that in a buy-sell arrangement that this would be exempt if the individual had 25% or more ownership. What if it was part of a buy-sell agreement? The non-compete, non-solicitation is with the selling of the whole company.
I'm sorry, I missed that last part.
That it's part of the sale of the whole company. And I don't know, Lewis. If
Yeah, the guidance that we have indicates that to the extent that the non-compete is in place, that the individual whom you're seeking to enforce the non-compete against must own at least 25% of the entity. So I think that what you can ascertain from that is if the individual in a buy-sell, whether it was part of the company or the whole company, owns less than 25% of the entity that is being sold, that the non-compete would not be enforceable under those circumstances, unless through the comment process, the FTC was to adopt a different standard. And honestly, that may well be an area that should be subject to comment, and we should be urging the FTC to change that rule, because I don't think it's realistic.
So if all the owners of the selling company agree to be held to the non-compete, so basically that would be 100%. You're saying that under the current provision, the way it's written, that would be exempt? That non-compete would and non-solicitation would still be valid?
Lewis,
Still gray?
Yeah, the guidance that we have, and there's not very much, Lewis, is that the 25% ownership seems to be a floor, so that it's not a proxy type situation where the other owners of the company could total 100%. It seems to look at the actual holdings of the individual who would be subject to the non-compete.
Okay.
That could well change through the comment process.
Right. If I understand you correctly, the 75% owner, you could still hold them to the non-compete. The 5% owners, you could not.
That's right.
Okay, that's.
But as you know, in a lot of these sales, nobody owns 25%. The key executives may own 5 or 10% at most, and are paid, and really have the wherewithal to impact the buyer in terms of future revenue.
Hey, Tony, it's Franco. Could I ask a question?
Sure.
And I'm not, I apologize if it was mentioned, but what about a non-compete that's basically, a garden leave type of thing, that we're going to pay you for not competing for a certain period of time? Is that still considered invalid under this proposal?
It is. One of the things to understand is the underlying determination in connection with this rule was that non-competes with respect to workers in and of themselves are a unfair trade practice, so that they're not getting into nuances around, well, what if they get paid, or what they're stating in a blanket way that non-competes are an unfair trade practice under Section 5 of their act. And based on that, they're nullifying those agreements. And it's not going to get into equities like you might in a court now. You might go into a court now and say, well, wait a minute, this person should be enjoined because they're getting paid, or they're, they're still employed, or whatever. They're not going to get into that under the current rule as proposed. That's why this, even in the dissent, they strongly encouraged employers to make comments in this area, because honestly, a lot has not been laid out in this rule. And it may be the only opportunity you get to do it in this way.
Can I ask a realistic question? I mean, how likely is it that this is, I mean, we deal with private equity funds every single day in these acquisitions. That's a main part of our business. I mean, how likely is this to go through? Or is this really an exercise, or we really think this strong of language is going to make its way through?
Personally, I think it definitely, well, I don't think, I know it will be challenged. It will be challenged in federal court, probably in a state down south. And the question is, it probably will be enjoined nationwide by some district court judge, maybe in Texas. And at that juncture, the question is twofold. One is, has the FTC gone beyond its scope of its regulation? The FTC has regulated, in before, and it does have supremacy in certain areas. I think the real risk for them relates to that Supreme Court opinion over the summer. That was the EPA case. That basically in the CO2 level regulation indicated that the EPA did not have the ability to regulate without getting Congress's legislative input first. And I do think that that's a definite possibility here. So, playing the odds in Vegas, I think it's about 75% that it gets enjoined, probably close to 90% that it goes to the United States Supreme Court. And the other thing is, what you're really asking me is who's going to be president in 2024, right?
Okay.
Because whoever the president is could, change it, because it's just a rule. If it's Biden, then the Supreme Court will likely decide by 2024. My hunch is that they'll follow the EPA rule here and say that they've gone beyond what they're required to do. There will be an interim effect, though. I think while this thing is pending, especially if it's not stayed, because I think some state court judges may well look at that rule and apply it in their analysis. If the rule has been passed and has been upheld, on its way up to the Supreme Court. Does that help you at all? Not really.
Like shooting in the dark, man.
So you're saying that the FTC, similar to the EPA, has the ability to come out with this regulation law, and it's something that does not go before Congress, like other types of law that get generated by Congress. Is that correct?
Yeah, in this instance, that's right. Yeah, right.
Okay, and that's what the Supreme Court came out in the EPA case and said, that they don't have the right or the ability to pass something that they passed without getting it ratified by Congress.
Yeah, so Congress should legislate in that area if they're going to legislate in an area that traditionally hasn't been the subject of administrative review. Yes, that's right.
Thank you.
Yeah.
So Jim, you mentioned that if I start to see the state legislation start to bubble up, if this goes final, it would preempt all state laws?
It would preempt as to certainly as to non-competes. Yes.
Okay.
I don't believe that it would preempt as to, although I think the law we're talking about is pretty much aimed only at non-competes, so it probably effectively would preempt almost the whole thing. Yeah, I think that's right. Which is going to be interesting in these states, because you're going to have a rule which has been passed that has a supremacy provision, and it's, you know, some courts, we could well have many different rulings across many different courts, which is going to, like I said, I think it's almost inevitable, just based on that alone, that it's going to go to the Supreme Court, because somebody is going to have to, there's going to have to be some coherent application of this rule across the country. And you may well have, you know, 4 or 5 Court of Appeals, you know, at the federal level that have reached different conclusions.
You mentioned non-compete, but you also mentioned earlier on confidentiality as well. I mean, is confidentiality provisions also at risk here? And trade
I'm
secret?
having a hard time thinking of an example where a confidentiality agreement could be so broad that it would be equated to a non-compete. They do mention the fact, and they raise specifically, they reference confidentiality agreements, if they're too broad, could be deemed to be non-compete agreements. But looking at a garden variety confidentiality agreement, it's hard to see how that could be that broad in general. I mean, obviously, if you had a confidentiality agreement that was written in a way to effectively prevent somebody from working for a competitor, then potentially that could happen. But generally, those agreements are not written in that form, so it would seem unlikely to ever, never say never, but it would be difficult to get one that would be broad enough, in my opinion, to be covered by this rule.
Jim, have we heard anything about any action or response from like the U.S. Chamber on the national level?
Tony, I'm going to turn that over to you. I have not heard anything from
Yeah, Dean.
the Chamber of Commerce on this.
You know, Dean, I know you sent me a note. I'm not even sure if the other business groups here are aware of it, but I haven't seen anything at the national level, Dean.
Okay,
And maybe that's a question for Tom Bracken, I mean, which I can try to connect with, but I haven't seen anything.
thanks.
I mean, the other part of this is, does this put the country at a disadvantage? You know, I on the one side, they point out how this is a very positive development. And kind of looking at from a competition standpoint, the question I have is, would companies that are thinking of opening up companies here, would that impact their decision maybe to go elsewhere? You know, where these might be enforceable. I don't know. It's certainly possible, but without really looking at the issue, but it is out there. If that became the law, it potentially could impact the way you might, you know, where regionally you might decide to open. You maybe go to another state or another area. I don't know.
Does anybody have an update on the New Jersey proposal? Is that dead or is that still alive somewhere?
No, that's a good question, and I was going to cover that. I mean, in the last legislative session, the bill bubbled up again, and I know all the business groups pushed back, and it kind of stalled. At this point, we haven't seen anything come back up, you know, but that doesn't, I mean, surprise me. They've been kind of quiet because they were focused on the congressional races and then the holidays. Now I think I'm starting to see some activity. I mean, I'll monitor it, but there is a bill. I can tell you that, and this goes back now well about a year ago, that the Assemblywoman on the Assembly side, Kahano from Elizabeth, understood our concerns, and on the Senate side, it's Senator Cryan and Senator Johnson, who we have a pretty good relationship with. I think they understood that it couldn't be, that broad. And I think part of the compromise was to say, because this all stemmed from, just to kind of refresh everybody's memory, there was a hairdresser in Elizabeth that signed a non-compete. I think she wasn't from the United States, so she didn't really quite understand that she signed something legal. Long story short, she goes to work somewhere else. They tried to enforce it, and then that's what prompted the Assemblywoman to introduce the bill. So one of our comebacks, or I guess conditions, where maybe set a salary level that anybody under that salary, that these non-compete agreements or restrictive covenants should not apply to, and they were open to that. So, but to answer your question, is not at the moment. There's nothing on the radar.
So Tony, my thinking is we should probably put together a comment to the FTC and make specific proposals in terms of their interpretation of this rule and its application.
Okay.
And cover some of the points I think we've discussed today.
Yeah, and then what I can do is I'll send whatever we develop to the other business groups, and maybe we could do a joint letter. And I think, Jim, I wouldn't be a bad idea to let our congressional delegation know, what our position is on this.
Yeah. Yeah, I think that makes sense.
So any other comments, thoughts before we adjourn? If not, Jim, I want to thank you for, spearheading this effort. I know I appreciate it, and I want to thank all of you for joining us today. And stay tuned, because you'll see an email from us. So again, we have some time, but we'll definitely get the ball rolling on it. So thank you, Jim, and thank you, everybody.
All right. Have a good afternoon.
Bye-bye.
Tony.